I'm Katy Wills. I'm a partner at Burr & Foreman. I'm located in our Mobile office. This is my 22nd year with the firm. And like a lot of my partners, I specialize in labor and employment law. And I'm happy to be here with you today. And I thank you for taking time out of your busy summer schedules, busy Fridays, busy coming up on the 4th of July. We're recording this the week before to address what we believe to be an important topic always, but particularly in the current legal and political climate, and that is the FLSA. FLSA, not necessarily the most exciting of topics. There's a bit about it that can be very technical and dry, but the tricky part about it is because it is so technical, if the DOL comes to audit you, they are more likely than not going to find an issue, not because you're deliberately doing something wrong or have malicious intent, but simply because the rules of the FLSA itself was enacted back in the 1930s. And so some of the language is very antiquated and therefore very difficult to comply with in today's world of email and cell phones and technology. Let's cover the basics, first of all, that you all know. The overtime pay requirement is 1.5 times the hourly rate for hours worked over 40 in a week. Sounds pretty simple, and in most cases it is, but we're going to look at some issues that have come up as it pertains to what is the regular hourly rate, what constitutes hours worked, and what does your work week look like. A key point, and one I think that we often overlook, and one that really gets employers into trouble, is that salaried does not mean exempt. Simply because an employee is paid a salary does not mean that they meet a specific exemption under the FLSA. That's a very, very common mistake. And looking at exemptions can require some difficult conversations, some changes, and we're going to talk about in this webinar how to handle those situations. The statute of limitations, how far back can a plaintiff go or can the Department of Labor go? And I think that's an important point. There are two fronts on which an employer can be approached about a potential FLSA violation. The first is through a Department of Labor audit. Those of you on the webinar who have been through such an audit will probably agree with me when I say if they come to audit, they're going to find something, even if it's something relatively small or minor. They can look back 2 or 3 years. Likewise, a plaintiff can file a lawsuit individually without having gone through the Department of Labor, whether it's for overtime pay or being misclassified or some other pay issue covered by the FLSA. And I think we're ready to progress to the next slide. So where are we as we sit here today on June the 28th? In order to be considered exempt, an employee has to pass the salary basis test and the duties test. Like I said, salary doesn't mean exempt. And the most common exemptions that we see is our executive, which we're going to talk about, administrative, professional, computer, or sales. But there's another part to that, and that's the salary. Currently, employees or workers have to earn $35,568 annually, which breaks down to $684 a week to qualify for an overtime exemption. So it's a two-pronged test. Do they meet the duties and do they have the appropriate salary? $35,000 in today's world and with inflation and changes in the economy doesn't sound like a lot of money. And so, of course, increasing this threshold salary basis has been a long discussed change. We're ready for the next slide. Back in April, late April of this year, the U.S. Department of Labor issued final regulations that increases that $35,000 number that I just quoted. The new regulations now raise that weekly salary from $684 to $844 or $43,888 annually. The kicker here is that starting Monday, it has to be that number. And then that number will increase again come January 1st to overall salary of $58,700 $656 a year. The duties test, fortunately, is not altered or changed. And then we also know there's an exemption for highly compensated employees. That number was is going to be 132, almost $133,000 come July, and then $151,000 come January. So this is a staged process, meaning there's going to be changes come Monday, July 1st, and then again in January. So it is a perfect time for you all to be considering your pay practices. And if you haven't already, we're going to talk about some steps of how to deal with this change and what modifications you may need to make. We're ready for the next slide. All right, let's talk about the exemptions. I promised we would. Executive employees, their primary duty has to be the management of the business or recognized subdivision of the business. That could be the accounting department. That could be the quality department. That could be maintenance. But it's generally somebody we would classify or talk about as being manager level or above. Pretty much they have to direct the work of 2 or more employees. And if the DOL comes out to audit you, they're going to ask them questions about how much control these individuals, these executive employees actually have. Do they have the ability to hire or fire other employees, or to have their recommendations given serious consideration regarding hiring and firing? Most often, I think, especially in the manufacturing industry, we see employers get tripped up on what we call a team leader position. In many instances, the hourly employees themselves may view the team leader as really their boss because they're handing out schedules and they're tracking attendance and things like that. But if that team leader does not have the ability to hire or fire or otherwise give recommendations that are afforded particular weight, they are not going to qualify for the executive exemption. This is one of the easier exemptions to be able to address because either somebody directs the work of 2 or more employees and it has this type of control, or they do not. But still, there are problem areas, and we would encourage you that if you've got people who are on the fringe there that you're concerned about, that let's talk about it further. Next slide, please. Administrative employees. I detest this exemption. I mean, it's been in place always, but it's one of the most difficult, I think, to analyze, to get right, and to defend if you're questioned on it. The primary duty of the exempt administrative employee has to be the performance of office or non-manual work. So we can't have a machine operator, for example, or a forklift driver qualify for the administrative exemption. Their duties must be directly related to the management or general business operations of the employer or the employer's customers. That could be somebody in finance. That could be somebody in accounting or benefits. One of the kickers here, the primary duty must include exercise of discretion and independent judgment as to matters of significance. Now, what in the world does that mean in plain English and not legalese? Well, it means if you've got, for example, a benefits administrator, I would tell you probably the first part of that test is satisfied. It's office and non-manual work. It is related to the general business operations of the employer, providing benefits for the employees. But if that benefits administrator is simply looking in a manual to figure out how to handle a particular situation or whether to approve or deny an insurance claim, for example, that's not exercise of discretion. Likewise, let's think about somebody like a procurement specialist or somebody in procurement or purchasing. If they have to run to their supervisor or manager to get approval, that they can't sign off on POs or invoices, then they don't get to exercise independent judgment and discretion. And this is a test that you really need to explore before classifying employees as administrative in nature. Perhaps the most commonly misused form of administrative employee that I have seen is the term specialist. I see now that there are 55 participants right now in this webinar, and I would imagine maybe close to half of you have a title called specialist. Now, I'm not saying get rid of it. I'm just saying it's a term that is thrown around in different industries for different types of jobs, and usually this administrative exemption gets slapped onto it. But you need to make really sure that these elements can in fact be met. Next slide, please. Professional employees, they have to have the primary duty of performing work that requires knowledge from an advanced type in a field of science or learning customarily acquired by a prolonged course of specialized education. Of course, they must also be paid on a salary basis. The alternative is that they have the primary duty of performing work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. So maybe, a creative director might satisfy that prong. The more commonly used prong of the professional exemption, though, would be the first one regarding knowledge of an advanced type or a prolonged course of study. Please keep in mind, probably the most common mistake we see with the use of the professional exemption is the term engineer. If somebody is truly an engineer and has gotten an engineering degree or is a PE or other designation, I would feel comfortable with advising an employer that they're probably going to meet the professional exemption. However, if it's somebody we've labeled an engineer, production engineer, they don't have the degree, the schooling, the education, the specialized knowledge, you're going to have an uphill battle proving to a plaintiff's lawyer, a court, or the DOL that they are in fact a professional employee. Next slide, please. Other exemptions, less commonly used, but still outside sales. The tricky part there is that someone for whom you are claiming the outside sales exemption cannot in fact be doing or tasked with doing inside, meaning intercompany sales task. The computer professional exemption, this is another tricky one. Probably almost everybody has a help desk, an IT department. The person that answers that phone when you have to troubleshoot may not necessarily meet this exemption unless he or she or they have some specific job duties. And then we have the motor carrier exemption. People are transporting goods across various state lines. Next slide, please. Okay, so what are good practices, good employer practices to engage? Audit your wage and hour practices. Right now is probably prime time to do so, simply because we've got these changes coming ahead in July and then again in January. With those changes coming, I do believe that you all can anticipate more frequent Department of Labor audits. We have also seen, at least in Alabama and in some other states, an increased focus on child labor. Back in August 2023, the DOL published an emphasis on child labor due to some media attention on some child labor allegations. That being said, we know a number of companies that have been subjected to checks on child labor, and when the DOL shows up to do that, they say, we're going to look at your wage and hour stuff too. So let's go ahead and start pulling out your payroll records and your exemptions and all of those things. So I think between the changes to the salary basis and the emphasis on child labor, if you haven't seen it already, you will see some increased DOL enforcement activity. Make sure managers and supervisors are engaged and educated. And what I mean by that, they don't have to understand the legalities and the nuances of all the exemptions. What they do need to understand, and I think you must emphasize this, is that they cannot require their subordinates, their employees, to do off-the-clock work. We all know that we've got that diligent employee who wants to come in every morning and get her workstation ready before the shift starts, or the gentleman who's worked for the company a long time and stays afterward and always cleans. 5S is very important to him. We have to pay those people for that time, and if our pay system is set up that it runs a shift time versus an actual punch time, then we need to make sure they're getting paid for that time and that they are not performing work off the clock. I mentioned at the beginning of this webinar that the FLSA and its language are old. They're a bit outdated, but one of the provisions that still continues to apply is that an employer is responsible for tracking and managing the hours and keeping a record of said hours of its employees. The burden is on us. The FLSA also says that an employee should be paid if they are suffered or permitted to work. Well, if we know that they're working this additional time, we've got to pay them. Make sure your policies and practices are not flawed. That goes back to the audit. We would highly encourage that if you do an audit of your wage and hour practices, that you utilize counsel in doing so that you can attach some privilege to it. More than one time, we've had the Department of Labor show up and ask for the results of any audit. If that audit is not attorney-client privileged, you're going to be turning that over and possibly revealing all the flaws in your wage and hour practices for the Department of Labor to see and further investigate. If you do find issues, problems, or where changes need to be made, you must perform very carefully orchestrated changes. What do I mean by that? Well, remember that 2 to 3 year statute of limitations. Let's say that you decide in July your goal is, yes, we're going to get a wage and hour audit. And through that audit, you figure out that there is somebody that is classified as exempt who is simply not exempt and that you need to make that change. Well, probably not the best bet and best communication to go to that person and say, we've had you misclassified for the last several years, and now we're going to switch you to a non-exempt employee. Obviously, we want to be transparent with our employees. We are not going to misrepresent anything, but you want to communicate things in such a way that you are not inviting, hey, what about my back pay for the last 2 or 3 years? That's still a possibility. It's still a risk factor that you need to manage into your process and manage into your changes. But we find that it is often best if you've got changes to make multiple changes at the same time. That way, you're able to control the communications. You're able to arm your managers and supervisors with FAQs if necessary to be able to answer employee questions or inquiries about the changes to the practices. It's always a good idea to have a backup method of verifying employee time. We like and recommend if employees have to sign off on their time or somehow have to validate it or verify it, because it becomes less easy for them later on in litigation to challenge, you didn't keep accurate time records, or I've worked more than this, if they are signing off on that. Your handbook should definitely contain a complaint procedure on how to raise issues about paychecks, pay concerns, I'm missing some hours, I think my manager altered my hours, and a definite role or person to whom those complaints should be reported. With that complaint procedure, you should also ensure that, just like reporting sexual harassment or race discrimination, that you ensure that there is a provision that it assures employees that they will not be subjected to retaliation for raising concerns. Make violations a discipline and not a pay issue. And what do I mean by that? Again, we have to pay employees for hours worked. Simply because supervisor did not approve weekend overtime for Sally does not mean that we don't pay Sally for that time because it was not previously approved. We may discipline Sally for not obtaining the prior approval, particularly if she's done this on a repeated basis, but we have to pay her for that time. Another issue, and probably too deep to get into in the time that we have today, is whether you want to consider having arbitration agreements for your employees for wage and hour disputes. This may be particularly helpful if you have concerns about potential collective actions. And keep in mind, collective actions are they are the cousin of class actions in the FLSA world, where you have plaintiffs who can opt in. The danger of collective actions is that an opt-in notice not only goes to current employees that may be impacted by the pay practice at issue, but also former employees who may not be very happy with the company and may not be happy with things, and they may be entitled to join the suit and opt in. Next slide, please. Okay, so preparing for some of these changes and some of this emphasis, what do we need to do? Next slide. Right, if you haven't already, you need to know your workforce and gather data and information about what people are paid. More particularly as it pertains to the salary basis test, you need to see, do we have anybody who's going to be impacted, and how many, and what kind of hit is that going to be into any sort of budget? You may be answering to upper management about that. You want to consider employee morale. What do I mean by that? It doesn't make sense necessarily to say consider employee morale when I'm sitting here and telling you, you must comply with the FLSA. But there are some people who may not qualify for an exemption now based on their salary. They're going to take it as a demotion if you move them to non-exempt, even if that means they might have the opportunity, in fact, for some overtime pay at time and a half. So you've got to consider how to manage that. Is it raising their salary? Is that fiscally possible? Or is there some way that you can help ease the transition if they've got to move from exempt to non-exempt? And you need to make sure you're reviewing your policies and procedures that they adhere to all of this. Next slide, please. What payments, and when I remember I said at the beginning that what payments have to be included in the regular rate. And remember, the regular rate is so key because it's that 1.5 times the regular rate that equals that all important overtime pay for hours worked in a work week over 40. Commission payments, non-discretionary bonuses like production. If you all, hey, if we hit this KPI, you get this bonus. If it's non-discretionary, has to be included. Shift differential payments. If somebody gets paid a shift differential, that has to be factored into the regular rate. Premiums for varying work duties, like a step-up supervisor, and flat payments for work outside the regular schedule, like an $100 payment for weekend work. So those have to be included in the regular rate calculation. I know a number of you utilize payroll companies. There is absolutely nothing wrong with utilizing payroll companies, but guess what? As the employer, even though you have delegated and assigned this responsibility to the payroll company, it is still your legal obligation to make certain that these types of payments are being included within the regular rate so that your employees are being paid correctly. It's always a good idea if you've got these payroll companies, or if you start a relationship with a new payroll company, to sit down, get to know your representatives, and make sure everybody is on the same page. Next slide, please. How do you include bonuses? This is a very technical slide. You add the bonus amount and the other payments, whether it's the shift differential or the others on the previous slide, to the total regular pay for the time period in which the bonus is being paid for or awarded, recalculate the regular rate, and determine the difference in the amount of overtime received. This is easier when you've got a single work week. I know this is more difficult if it's a quarterly bonus. And this is probably a topic to talk about offline because everybody's situation is going to be different. Next slide, please. I'm not going to try to do math on this Friday morning, but we've given you a simple example to look at and consider about how a regular rate and a bonus calculation would figure into that regular rate. And you can see how this would be done. We've used nice even numbers. We realize you're not always going to be working with those. Next slide, please. Non-discretionary bonuses. These are bonuses paid in recognition of services performed during a given time period if the fact that payment is to be made and the amount of payment are determined at the discretion and not pursuant to any prior contract. agreement, or promise causing the employee to expect payments regularly, not pre-announced. Next slide, please. How do I ensure that I'm providing a discretionary versus a non-discretionary bonus that would have to be included in the regular rate? I don't pre-announce it. I don't say every, I don't say now on the 31st or the last day of every month, this is what you're getting. I don't announce stated conditions of the bonus, certain results. It's not an established or a predetermined amount. We need to be able to tie that bonus to a particular time period. It can be discretionary. An employee of the month can be discretionary if there are no set out criteria, and Christmas bonuses or gifts are considered discretionary. Next slide, please. Pay periods. Remember, we said what a work week was. Keep in mind that's important because the regular rate and overtime has to be calculated on a work week, not a 2-week pay period. Some payroll companies have programs that average hours or rates across a 2-week pay period, but both the hours and the rate have to be calculated only on the work week. If the employee works 2 or more rates, you have to use the weighted average of the rates and make sure you know how your payroll calculates overtime. I hate to say this, you may find errors. Next slide. Deductions from exempt employee salaries. Remember, we went through the exemptions. As a general rule, if the exempt employee performs any work during the work week, he or she has to be paid his or her full salary amount. That's not usually a problem, but it can be a problem if I've had calls before of this person doesn't show up to work and comes in a couple of days a week, and we don't really have an attendance policy for an exempt employee. But they are entitled to be paid. We may not make deductions for absences that we cause or by the operating requirements of the business. If the exempt employee is ready, willing, and able to work, we can't make deductions when no work is available. That, you didn't have enough work this week, and so we are going to deduct your pay, or we only had enough work for you to do 3 days this week, so we're going to pay 3/5 of your salary. Keep in mind that an exempt employee's first and last week of work, you do not have to pay the full salary. You can pay based on when they started or prorate. Next slide, please. As a general rule, we know the general rule, if they perform work, we have to pay the full salary amount. Partial week deductions are not allowed except for full day absences for personal time, for sickness or disability, if we have some kind of sick leave or sick pay or PTO bucket that pays them for that. Disciplinary suspensions, for example, if you're investigating them for a major safety violation or maybe a sex harassment investigation. Family and medical leave, and the first and last weeks of employment, like I said. Safe harbor provision, what do I mean by that? That's really part of your complaint procedure, which is that you need to have a way that if an exempt employee feels that their salary has been subjected to an inappropriate or improper deduction, that they have a method of raising the concern, and we have a designated person who can address the concern. Next slide, please. Hours worked. Next slide, please. When do we have to pay for employee training? We don't necessarily have to pay. We don't have to pay for training if it's outside the regular workday, the regular working hours. If it's completely voluntary, that maybe this employee wants to learn a new welding skill. If it's not directly related to their current job position, and if they're not during the course of that training performing any sort of productive work for the company. Next slide. Preliminary and post-preliminary activities. Again, this is some of the jargon that comes along with the FLSA. We have to pay for activities which are preliminary to principal activities and are considered integral and indispensable to the performance of the preliminary activities. What does that mean? If that means that we have to do a certain setup of a machine prior to its operation, or we require our forklift operator to inspect the forklift before jumping on it and beginning work, that would be an activity requiring compensation. Exempt from compensation, walking, riding, or traveling to and from the performance of work. Walking from the time, not necessarily, walking in from the parking lot, that's not compensable time. Activities that are preliminary or post-preliminary, which occur either prior to the time on the work day when we commence work or after that time. Next slide. Work activities includes functions of the colleague's job. Like I said, preparing workstations, gathering tools, prepping paperwork, checking equipment. Work activities usually does not include putting on standard PPE like earplugs, safety glasses, sleeves, things like that. But if you're in an industry where there is substantial PPE, where there's excessive PPE, you may need to evaluate whether that's going to be considered outside the realms of standard PPE for purposes of compensation. Next slide. When we say the term integral and indispensable, simply we mean we require the activity as the employer. The activity has to be undertaken in order for the employee to perform his or her duties. And this activity doesn't really necessarily benefit the employee, it benefits the employer. Next slide. Meal periods. This can be a hot button, particularly in the era of cell phones. It used to be maintenance folks and radios getting interrupted at lunch with questions because a machine had broken down. We have to provide a bona fide lunch or meal period. We don't have to pay for it if it's at least 30 minutes long and people are completely relieved from duty. That doesn't mean that we have to allow the employee to leave the work site. It doesn't mean that if I walk by my assistant's desk in an office area and drop something by her desk and say, when you get done with lunch, because she might be eating lunch at her desk, when you get done with lunch, I'd like to talk to you about this. That would be a minimal interruption. But if the maintenance person, takes 2 5-minute calls on his cell phone while he's sitting in the break room trying to wolf down his McDonald's, that may be enough of an interruption, more than de minimis, that will require us to pay for that 30-minute lunch period. Again, you need to have a reporting procedure that employees can utilize in order to be able to report if they have had an interrupted meal period. Next slide. We had a couple of questions come in the box, and I'm going to address those now. If you have any more, feel free to include them. I know this is kind of a quick and dirty on the FLSA. Some of these are obvious. Some of these are well familiar to you, but we can all use the reminder. One says if your handbook classifies a discretionary quarterly bonus to production and can be removed, do you have to use this for the regular rate? I think if, it depends on the wording, on how it is worded in your handbook. You are announcing that is a possibility, but if you are not setting out that this is when it will be paid, this is how it will be paid, this is to whom it will be paid, and you are reserving some company discretion as to whether it will in fact be paid, I think that you will be able to make a good case for calling it discretionary, not non-discretionary. Is there anything that will be stopping the 7/1/24 date? I have not seen anything recently come down. Who knows? It's Friday. You never know. But we do anticipate that this is happening. It's been so long discussed that we do anticipate that this will be coming into play. And now that doesn't necessarily mean, I don't know if that means necessarily that something wouldn't happen between now and January that would inactivate the bump up that's scheduled to occur on January 1st. With that, I don't see any more questions. always, I know that we're going to be sending out the broadcast for you to re-listen to or have at your disposal. You are welcome to contact me directly via email or otherwise to address any company-specific questions, any questions that you felt like you didn't want to have answered in an open forum. I'm happy to answer those, or you're welcome to reach out to any of my Burr and Foreman colleagues to do so. With that, we will conclude the Burr Morning Show on the FLSA. I thank you so much for taking the time to be with me on Friday morning, and I hope you all have a wonderful weekend and a safe 4th of July. Thank you so much.